Hi, this is Scott, and I'm here at the Troutt Law Firm studios to talk about court. I'm here to talk about presentation, about the way that one should look whenever they're going to court. There's a range of beliefs on whether or not one should wear a suit or go business casual. I'm here to talk about my preferences. Number one, if you're a guy, you should probably wear a suit. If you don't own one, that's okay. At least wear a colored shirt, long sleeve if you can. Do not, under any circumstances, wear shorts or flip-flops. Two worst things that anybody can possibly do. No matter how good you look on the top half, the shorts or the flip-flops will completely destroy it on the bottom half. Number two, wait for just a split second after an attorney asks you a question or a judge asks you a question to respond. This is extremely important because there's a record being made of everything that you say in court. In the event that you don't stop, it's entirely possible that your statement will either not be written down or it will end up in bits and pieces of a record. In other words, it'll be 2 words of what the attorney's saying, followed by 3 words of what you're saying, followed by 2 words of what the attorney's saying, and it just goes back and forth. It makes for a bad record. And in the meantime, just for practical purposes, it's really, really difficult to keep up with. Number 3, and maybe some of my fellow attorneys will balk at me saying it this way, but don't do hearsay. Hearsay is when you say what somebody else has said to you. So it's a third-party statement, if you will. To be exact, it's a statement that is made for the truth of the matter asserted by another person who is not a party to the case. If that sounds very complicated, it is. The easiest way to explain it is just don't say what other people said. It's okay to say what the guy who's on the other side, or lady, said, but just otherwise don't do it. Number 4, get to the point. Answer the question that is asked, not the question that you want to have answered. That's not how court works. You are going to get a litany of extremely unfair questions during cross-examination. That's part of the point of cross-examination, really. And you don't get to answer the question that you think should be asked. You get to answer the question that is asked. The quicker that you answer the question and the simpler that you answer the question, the quicker it will move on and you can get to a better question for you. Number 5, demeanor matters. If you are sitting in the witness box or if you're sitting at the counsel table, you should do your best to at least keep the emotions down. When somebody says a lie, it really doesn't help anything to sit there and shake your head. If somebody says the truth, it really doesn't help anything to sit there and shake your head. Try to keep it down as best as possible. I understand it's a highly emotional procedure, but it is best to avoid it if you can help it at all. I'm hoping that these tips will help you the next time that you are in court, which hopefully will also just be never. But if you happen to end up there, please consider giving us a call here at the Troutt Law Firm. It's 870-933-7100. Thank you.